Now to South Africa, the third day of the Oscar Pistorius trial. The chief defence lawyer has been seeking to undermine the prosecution testimony of a couple who say they heard a woman's screams and gunfire the night the athlete fatally shot his girlfriend. In court, a fourth witness has just been testifying about a separate gun charge when Oscar Pistorius allegedly fired a shot under a table. The athlete has pleaded not guilty to intentionally killing his girlfriend, Reeva Steenkamp. Let's go to my colleague Karan Giannone, who joins me live from Pretoria, particularly on this issue of what was said in court about that incident in a restaurant.
Yes, Nick, Kevin Lerena, a professional boxer who was out for a meal with Oscar Pistorius and some other friends in January 2013. And one of those other friends handed Oscar Pistorius his pistol. Oscar Pistorius apparently had a look at it, and it's alleged that the gun went off in Oscar Pistorius's hand accidentally, just grazing the toe of Kevin Lerena under the table and causing a lot of shock and consternation. And why the prosecution have brought in this firearms charge, an additional charge to the one of murder, is obviously to try and paint a picture of Oscar Pistorius as a trigger-happy, irresponsible, reckless person who would have been capable of what they accuse him of on the night of Valentine's 2013. Let's just hear a little bit of Kevin Lerena's testimony. He is the first witness to agree to be shown live on camera. The other three before him have all declined to have their faces shown.
You saw the gun being passed under the table?
Well, the movements, the actions. I didn't see the gun.
Okay. And you heard what Mr. Fresco said?
I'm one up.
One up. What do you understand by one up?
That there's one loaded into the chamber.
Okay.
That people who carry guns, I suppose, carry one up.
Okay. And what happened next?
A shot went off. A shot went off in the restaurant, and then there was just complete silence. Once the shot went off, I looked down, I was in shock, and I looked down on the floor, and exactly where my foot was stationary, there was like a hole in the floor.
Well, the court has been adjourned for procedural reasons. It will reconvene after lunch, so we're waiting for things to get underway in probably around 50 minutes' time. Now, with me is Marius du Toit, who is a criminal lawyer in Johannesburg. And Marius, what have you been making of the events so far? I mean, the order of the witnesses, the actions of the defence, and how tough Barry Roux has been on particularly two of the prosecution witnesses.
I think one must understand, firstly, that there's no sequence specifically to the witnesses being called. The state or the prosecution team has to fill the court with a number of hours. So they basically have to make sure that there are always witnesses available to testify. So the court doesn't want to adjourn. So this morning when they had Johnson, for argument's sake, that wanted to consult something on his iPad, it was only common cause that they would call another person to come in his place.
Right, so Charles Johnson, number 3 witness, the husband of Michelle Berger, he also underwent so many cross-examination hours that we heard.
Well, I think one must understand that, you know, what the state is trying to seek with this evidence. I mean, the state is adducing evidence of people, of Reeva screaming. That's what they're trying to do. And by doing that, that will, of course, refute Oscar's version that there wasn't an argument. So you must understand that this matter is central to the state case, and it's central to the defense case. So Barry Roux has got a very specific duty to make sure that this evidence, the value thereof, must be so little that the court cannot really take into cognizance. Alternatively, give a plausible explanation for the way they testified. And that's why he's been going hammer and tongs after them.
And do we expect more of that once they've got whatever they need? They needed more documents, they needed to get something off the iPad.
Yeah, you must understand, whenever a witness during testimony refreshes his evidence, all right, or refreshes himself from anything, or he said, I made notes, and based on those notes I'm testifying today, he immediately opens the door for the defense to say, well, listen, seeing that you refreshed your memory, kindly provide that to us so that we can have a look to see if you're consistent in your version. Because that's what it shows about it. It would show credibility on the part of the witness. If that witness sticks to the same story he had back then, of course it shows the witness is credible.
Now, we had Barry Roux, Oscar's lead counsel for the defence, saying they didn't actually have any, they weren't expecting this fourth witness to appear at that particular moment. They needed some time to prepare, so that the court was adjourned a little bit early before lunch. What was going on there?
Well, I think you must understand, they prepared for Johnson to be cross-examined. And like his wife, I assume that Johnson is going to be in the box for quite a while. You know, he's going to get some grilling there, I believe. So the moment he stepped down, or the moment there was suddenly an intervention that he had to get his iPad to get the notes, when that happened, it immediately meant that the next witness had to be called. But they are not prepared because they assumed, at the very least, they were going to cross-examine him at least for 1 or 2 days.
Right, and you don't think there's anything unusual about why they chose Kevin Lerena on this completely separate firearms charge to come and testify?
One must understand that character evidence is usually not allowed during a trial. So I cannot adduce evidence to show that Oscar is a bad person. It's simply not allowed in our courts unless you as the defense attorney goes and you open up a door by saying, listen, my client is a fantastic guy. You know, he's just the best person ever. Then suddenly you open the door for the state to attack that credibility. But as a rule, credibility is not allowed to be attacked. So what is the state trying to do? They're trying to show that Oscar Pistorius was a person that was a bit gun-ho, grabbed the gun, discharged a shot, which in essence is character evidence. But they're doing this by adding a charge. So because there's a charge to this effect, and understand the sentence on something like negligent discharge of a firearm is petty compared to the charges he's facing. But that's the only way they would be able to adduce that evidence is, of course, charging him separately with such an offence.
Marius du Toit, for the moment, thank you very much indeed. And as I said, in around 45 minutes' time, we're expecting the court to resume its proceedings again, and we'll bring you and continue to bring you the very latest developments from inside.
Karen, the BBC's Karen Giannoni there.